Afternoon. This is U.S. Immigration Attorney Sharifa Tharpe. Happy Monday. I am back today with a great topic. I'm going to answer this question for you. Can an employer get you a work permit? The answer could be yes, and it could be no under some circumstances. It just depends on your circumstances. But I'm going to tell you in general terms when an employer can get you a work permit versus when an employer can't. So when we talk about work permit, I'm not talking about a visa to come to the United States to work. An employer who's here in the United States, depending on what you're coming to do, if you're coming to do seasonal work or if they want you to come permanently, can get you a visa to either work temporarily or to even come into the United States to get your permanent residence. So I'm not talking about a visa where you're outside of the United States and coming into the country. But you do have situations where the individual may be outside of maybe in the United States. And at that point, they're asking, how can I get a work permit? I'm here now. You may have overstayed your visa. And now you're trying to figure out, how can I get the work permit? You may be working or you may be talking to an employer who could possibly be telling you that they can get you the work permit. And I want to empower you with the right information so you don't even fall for scams or you don't fall into a labor trafficking situation. Because many of my clients who have been in this situation, so I have learned from my clients and from educating myself about trafficking situations, how these situations start out. And I want to stop you from possibly falling into that situation by knowing when an employer can get you a work permit versus when an employer can't get you a work permit. Now, the first thing I want to say is that if the employer tells you that you're here in the US and the employer tells you that you have to start working for them first before they can get you the work permit, be very cautious about this employer. They may be trying to get you into a situation where you start working for them and then you don't get anything from it. Because in this situation where they haven't gotten you a visa, you haven't gone through the channels to adjust your status or to change status to be able to work for this employer, and they're just out of the blue telling you, I'll get you the work permit, but to get you the work permit, you have to work for me first. False. No, you are not supposed to be working for an employer without a permit. So if an employer is promising you that, it's false. The employer has to first help you to get the work permit before you start to work for them. So that's the first red flag here is any employer. And if any employer has promised you the work permit and you're working for them now, and now you feel like you're in a situation where you're stuck or they're mistreating you or they're dragging you along, I'm the person to talk to because there may be a labor trafficking situation and there's immigration relief for this. But this is usually the first red flag with my clients that have been in this situation. Now, some clients end up working for an employer knowing that the employer isn't going to get them a work permit. And that turns into a labor trafficking situation as well. But in the situation, you can spot this red flag. Um, so you can spot this red flag from a distance, and that is they are telling you that you have to start working for them first before they will get this work permit. So no, that's not possible. Let me tell you where an employer can get you or how the employer can get you the work permit. So the employer can get you the work permit if you're here and they have already submitted a petition for you as well as and then you have to submit an adjustment of status application. In that case, then at that point, you would be able to possibly get the adjustment of status application, get the work permit with the Okay, so let me just come out and go back in. Okay, so I'm seeing that you're not hearing, so I'm gonna come out and go back in. Thanks for letting me know. So I'm gonna come out and go back in. All right. Okay, so I just had a technical glitch there, and I see your question on YouTube. I'm going to get to it in a quick minute. Yeah, so this is very relevant on YouTube, so I'm going to get to your question in a minute. Thanks for your patience. I'm sorry about that. So I lost sound. Now I'm back. And we were talking about that first red flag. When an employer promises you to get the work permit, but they say first, you need to go ahead and start working for me first. Thanks so much, Carol. Um, in that case, red flag. The only way that an employer can get you the work permit is one, they first file a petition for you. That petition is going to enable you to apply for adjustment of status. Adjustment of status is where you are staying here in the US and you're applying for permanent residence. So, as you can see, there's a bigger commitment here. The employer can't just submit a little application and get you a nice, neat little card for you to start working here. There are channels that you have to go through. And so the employer usually, when you're working, getting a work permit, I'm not talking about a visa. That's where you're outside of the US coming in, or you're coming in with a visa. Not talking about that. I'm talking about that work permit that people get on when they qualify for certain benefits, they get this work permit in the US. And in this case, the employer files a petition, and along with the petition, you file an adjustment of status application. And that adjustment of status application can enable you to get the work permit. If you're not going through that process, or if the employer isn't establishing a process like that first, then chances are it's fake and they're giving you a false promise, a fraudulent promise. And this is a first red flag for labor trafficking. Many of my clients have gotten into that situation where they're promised status, they're promised a work permit, they're promised a social security number, and then they find themselves in a very ugly employment situation where they feel stuck or they feel afraid to leave because now the employer has the person thinking if they leave they're going to lose their chance to get status, or have them it's until afterwards they have them here without the work permits but working, and afraid that the employer is going to have something on them to go to report them to ICE. So that's usually the first step. So if the employer is saying that, be very wary. And I've told you how the employer is supposed to go through, one of the ways that they're supposed to go through the channels. Now, if they're not interested in getting you permanent residence, but they are saying that they can get you to legally work for them. Say you're here and you're interested in working for them, but you're going to go back home and then you want to come back in, they have to get your visa. They have to sponsor a visa if you're going through the employer, a visa for you to come back into the US. So there's no way that an employer can say, I want you to start working for me. I'm just going to go ahead and submit a special application just for the work permit so you can get to work for me for 2 years. Doesn't happen, right? So, can an employer get you a work permit? No. If you're here on say a visitor's visa, or you're out of status, or you overstayed, you cannot just get the work permit without qualifying in other ways. So if the employer is saying, I can get this for you, but you need to start working for me first, that is the red flag there. So look out for that, and you're wiser because of this information that I've given you, that the employer doesn't have special powers to be able to get you anything without going through the legal channels. The employer has to submit an application to get you your papers first before you start working. And I just want to elaborate more on how this turns, kind of give you a picture of how this turns into a labor trafficking situation. So the way that it usually works is they'll promise you the work permit, but come work for them. And they'll even throw in something like, you can come work for them. And then if you work for them for 2 years, so if you're in a work situation and they said that you have to work for them for a little while before they apply for you, just know that this is a fraudulent promise, because once you are working without a permit for an employer, you are not going to get a work permit through the employer. The employer is actually in violation of the law. They're violating the law by coaxing you to go ahead and work for them and promising you the work permit. There is relief for situations like this. And right now, the Department of Homeland Security, they have released a policy to consider and possibly grant deferred action to individuals who are the victims of labor law. So not just fraudulent promises like this, but if they're paying you lower wages than they should, if they're violating your federal employment rights, if they are discriminating against you, these are possible violations that could get you deferred action. This is where you can get your work permit and you can stay in the U.S. without getting, gaining accruing unlawful presence, or any unlawful presence being held against you. And this may also lead to bigger relief for you. This may lead to even getting the visa as a victim of or labor trafficking. So if you're going through something like this, get in touch with me. This is exactly what I help my clients with. I have gotten my clients this kind of relief. And this is a type of relief that not a lot of attorneys know to screen for. So attorneys will often just say there's nothing that they can do in a situation like this. If you're in this situation, there is something that can be done. I just need to evaluate and determine whether I can help you. You can always get in touch with me. My numbers on my video, the link is in the profile for you to go ahead and schedule time to talk. Now I'm going to answer questions, and I see on YouTube a very relevant question here. So can you qualify if you sued and won the lawsuit? So if you sued for employment issues, there's a possible relief there. I'd have to explore, for example, did you report the issue? Where did the lawsuit go? Who was involved in the lawsuit? Did wage and hour get involved? What were the facts related to the lawsuit? And this is in relation to the employment issue. So absolutely. If you have been in a situation like this where you sued, you even won, you don't even have to win a lawsuit, by the way. You don't even have to win a lawsuit. But if that's the case, then get in touch. We can talk. Okay, so can you qualify if you sued and won? So I did answer that. I have my work permit already, but waiting for my advance parole. How can I expedite it? I want to travel, and it is a risk if I travel to my home country and come back. So you can expedite it. Usually you have to submit it by phone. That's the policy right now. And then they will consider it, or they may ask you for additional information. So they might to like evidence to show that you need to expedite it. Now, to expedite, usually you have to have some sort of urgent circumstance, if or humanitarian issue. You have to show maybe there's some sort of economic loss involved to yourself or another individual or an entity to be able to qualify for this. So they are looking for your request to meet certain criteria before they grant it. And do not leave the country until you have that travel document. Because when you're going through adjustment of status, if you leave the country without getting the travel document, without having it in hand, it means that once you set foot out of the country, you have abandoned your application and they will deny it. Does mental issues help with that expedite for economic loss? So that's too specific. It really depends on how, how are the mental issues affecting the economic loss? And so, that's way too specific. I'd have to understand the context of that situation. If you do have an attorney, make sure you talk to an attorney about following through with the travel document. All right. What's the best way to file for your citizenship if you cannot read or on? Okay. So if you cannot read, then you will have to, needs to be waived in some way. So if you've, for example, if you're over a certain age, so if you're over 50 and then you've been here for a certain length of time, then you can possibly get some parts of the test waived. Another is if you are, say, you're disabled, and that could be part of the reason why you may be unable to read. If a physician completes a special form that shows how this disability affects your ability to pass the reading, writing, and civics test, they could possibly waive the entire test. But it's going to depend on the if the disability is connected to the inability to read and write. So that's those are the ways. If the person has to be over 50 to get to either get an easier test or to be able to get it waived. So over 50, they have different criteria, different requirements just based on age and length of the time here. But those will make the test easier or waive it altogether or waive it in English. But to actually get out of the test altogether, you need to show that there is some sort of medical condition that's linked to your inability to read or write in English. Can someone doing a sponsorship sign a prenuptial agreement? So that should be a question for a family law attorney as well. Prenuptial agreements are not, it's not something that comes up in the immigration context. And what the sponsorship, the affidavit of support could affect the ability to enforce the prenuptial agreement. I could see that happening. So you should definitely talk to a family law attorney, one that specializes in doing prenuptial agreements, because that attorney needs to know about this sponsorship. Because if say this is a marriage-based application and the sponsor is the spouse, the U.S. citizen spouse, and the immigrant, and they're looking at doing a prenuptial agreement, there could be a conflict because the government is signing a contract with the citizen spouse saying you have to step in and support your spouse financially, even in the case of divorce, for the next 10 years or until they become a citizen. And so the prenuptial agreement is usually prenuptial agreements say your assets are separate. It says in the case of divorce how you're going to divide things up or whether you're even going to divide things up. It usually means that the income or the support, financial support of the spouses is limited. And so there could be a conflict between the two. So you should consult with a family law attorney who can advise about how to best approach a prenuptial agreement. All right, keep those questions coming. These are all great questions, so put those questions in the comments. So is it advisable to travel to the US while your I-130 marriage papers are in process? So, it's a risk. I will say it is a risk, and whether it's advisable is going to depend on your particular situation. I do advise my clients on a case by case basis, just depending on what's going on. But when there is a pending I-130, an officer, especially in the case where it's a 2-year process, the officer can hone into that. And I have seen people turned around at the airport for having an petition pending and trying to come in at the same time, because they can construe it as you coming to try to stay. So it is a risk. What if they tell you that a decision cannot be made and a decision will be mailed to you? So it just means that they may have to review your application to determine whether you qualify. Maybe there are additional elements involved that they have to review. So at interviews you could get that, and then the next day you still get your approval. It's just that they need to go through the motions and just make sure that everything is correct before actually posting the decision. And then again, it can go for another year or two with them saying something like this. So it really depends on what's involved in it. Usually there is something that they need to look over before they make a decision. Does staying 5 months out of the country at once be an issue for naturalization? It depends on how many times you've done that. So, doing it 5 months out of that entire period of time that they're looking at, it should not be a problem. But if you're doing this every few months and staying 5 months at a time, 5 months at a time, 5 months at a time, then they could pick up a pattern. And the policy manual does say that the officer can look at your pattern of travel to determine whether you did try to live in another country while being also having permanent residence. So 5 months alone, no. But if you are doing 5 months, then you stay in the U.S. for a month, then you leave again for another 5 months, and you come back and you do a month, and then you leave again. That definitely can raise problems. Hi there, it's nice to see you. Can you file adjustment of status as an LPR for the spouse? Yes, but you do need to be very careful with that process. Where with the U.S. citizen, a spouse can be out of status, as long as they had legal entry, they can file adjustment of status even if they overstayed. With the legal permanent resident spouse, it's not the same. VAWA, if they're the spouse of a legal permanent resident and they're applying on their own based on mistreatment by the legal permanent resident, then that, staying or overstaying is still acceptable for VAWA. But if the spouse is filing the petition, the legal permanent resident spouse is filing the petition for the spouse needs to follow very specific rules to make sure they don't run into trouble. So you can always give me a call. I can see whether you qualify and then assist you, represent you through the process. So before COVID, was cases moving fast as the given time? So before COVID, it was definitely slowing down. Then COVID just made it really bad. Now they're trying to get back on track with adjustment of status. It is my experience with the adjustment of status process post COVID is it is moving at a fair pace. So I'm seeing anywhere from 5 months for the entire process to be completed to a year. So that's great. At the average I'm seeing is 5 to 8 months for the entire process to be completed, as long as it's done correctly and properly. This is where I like to warn people about trying to do it themselves, trying to get the wrong people to do it for them, trying to get these people on the corner that says they do everything under the sun, taxes, immigration, all of the restraining orders, they do it all. If you have someone who is doing that, then I usually find that those people are the ones that get, messes up your case. They tend to do a very shortcut way, submit the paperwork, don't submit the right evidence, and then you end up with the request for evidence. You end up with a bad interview, and that's what drags on the cases for a while, for 2 years or so. Um, I've seen people that have tried to do it on their own go through this process where it's turning into a 2 year process. But my experience has been positive because I'm so thorough with my clients' applications. All right. So I don't see any more questions. So I'm going to call it a day. Thanks for listening. Thanks for joining in. Thanks for participating, for answering your question, for asking your questions. I will be back tomorrow where I will bring another topic and you can always bring your questions. So I do see one more that I am going to go ahead and answer. And if you have any more questions, so I see another one. Retype it, please. I didn't see it. So retype your question, Aries Boss Lady, while I answer this one on YouTube. So, hi, I'm married with a USC and all my applications were submitted 8/23/22, biometrics 9/20/9/22. Do you know when I can expect any answer? So no, I wouldn't know when you're going to expect an answer. If you do have an attorney, make sure you talk to your attorney. Or you just have to wait. You can also contact them if you feel like you need to keep up. But at this point, it's a waiting game. How does the process go for a study permit in the US? So usually you have to get an F1 visa or an M1, just depending on what your area of study is going to be. And then if you're outside of the US, you're going to apply for a visa at the embassy. You usually have to be accepted by the school. The school issues an I-20, and then you can use the I-20 to be able to schedule the interview at the embassy and provide evidence of how you're going to support yourself to go through to be support yourself while you're a student. Does getting an H-2B visa affect the B-1, B-2 visa? No. So you can still have the B-1, B-2 and have the H-2B at the same time. If you're entering in as a worker, you'd enter with the H-2B. If you're coming in as a visitor, you'd enter with the B-1, B-2. Um, I already filed AOS 9 months ago with my wife and still haven't gotten EAD, and she's very abusive. Can I file VAWA and expedite my employment authorization? Absolutely. So I do help my clients once they're in a situation like this to switch. And it's the best thing that my clients have done. They have had peace and they do gain control of their own process. Now, when it comes to expediting the work permit, it depends on what the situation is. There are ways to request it, but with my clients, I make sure we can provide solid support for an expedite request because we can't just call them and say, "Hey, we need it faster." Also, if it's outside of processing times for the work permit, that can also be a way to ask them to get it faster, because if you're outside of the usual time for a work permit to be issued, at that point, we can definitely contact them. So get in touch with me. Let's talk about your situation and get it switched up ASAP. At this point, I usually say these cases are urgent because you want to get it switched up and get your process switched to you alone without the spouse. She will not know about this. This is something that we do where it's completely confidential. And so she will not know that you are filing now on your own. And the USCIS, they're required under law not to release that information to her as well. So if you're in this situation where you're being mistreated by a US citizen or legal permanent resident spouse, and you want to switch to your own process where you're applying on your own based on this mistreatment, it's possible. But it's something you want to get done ASAP before you end up getting scheduled for the interview. You want to do it at least as soon as possible. I have even done it when my clients have had to go to the interview, I have still switched out the process right on the day the interview was scheduled. So it is still possible. You just don't want to end up getting denied, because what you can do is continue your process with the work permit application, and your adjustment of status application pending with your own application and not based on a marriage based. So give me a call, schedule, and we can talk more and get started on it ASAP so that you can find that peace of mind and be able to know that you will make it on your own and you can gain control of your situation. Hi there, it's nice to see you on YouTube, all the way in Indonesia. Thanks for joining in. All right. So that's it. And you're so very welcome, Bob Risky. Thanks so much for joining me. And for those of you, my friends, always joining me here, thanks so much for your support and your questions and just listening in. All right. So I'll see you tomorrow at around the same time. In the meantime, hang tight, and you can always call to schedule time to talk about your situation to see if I can help you. See if you're eligible to get your permanent residence, get your work permit here, and be able to settle into life here in the US. So, looking forward to talking to you soon. Bye bye.